Before starting this agenda item, I'd like to acknowledge the work of my colleague Kelly Rice, staff attorney from Iowa Vocational Rehabilitation Services. She joined us today in case there were any questions. Her team did an exceptional job in doing a thorough rewrite of Chapter 56. So just wanted to bring her and her team's work to this board's attention.
Yes, thank you.
Next agenda item is an appeal decision regarding a challenged library book. I've provided you with the administrative record as well as the proposed decision. The proposed decision has two layers. First, a question of jurisdiction. Valley Southwoods Ninth Grade High School is a single-year building. And so if you're no longer attending that building based on prior board precedent, you are no longer aggrieved by any decision. The second layer was the reasonableness of the action that the board took. And the attorneys who are both here today and will be available to present oral argument and answer any of the questions that you may have of them directly. The question about the scope of review. Does the board exercise independent review, make its independent judgment, or does the board exercise board deferential review? And based on Iowa Supreme Court precedent, this board's prior precedent, the scope of review is deferential. In the words of the Iowa Supreme Court, the local board's decision is prima facie correct. And with that,
what do you mean by that?
It's presumptively correct. To overturn it, there needs to be a reason to overturn it rather than I disagree with it. Attorney Christy Latta represents the school district. She is here, the school district and board. She is here today. Attorney Alan Ostergren represents Ms. Patrick. He is here today to address questions about standing, scope of review, as well as the reasonableness of the board's action. But the scope of review, as presiding officer, once I looked at the scope of review, the board's policies, and weighed the pros and cons for keeping the book, removing the book, the merits of the book, with that deferential scope of review, my recommendation to you is that the decision of the West Des Moines School District Board of Directors, which was not unanimous on this question, by the way, be affirmed. And with that, I will yield the floor to my colleagues in private practice for oral argument. Practice is to start with the counsel for the moving party, Mr. Ostergren. And you may speak from wherever. Okay. Thank you.
Good morning.
Good morning. Good morning.
Mr. Mays, I'm sorry, before Mr. Ostergren begins, is it practice to allow the speakers to complete their arguments before asking questions, or is this more of a back and forth?
It's your board meeting.
All right.
So it's
And certainly if a board member has a question, please feel free to ask it during my remarks. This is formal, but it's also informal here in this meeting. My name is Alan Ostergren. I'm president and chief counsel at Kirkwood Institute, which is a public interest law firm based here in Des Moines. I'm here on behalf of Terry Patrick, who's seated behind me, a parent of a student in the West Des Moines schools. We started this appeal process, and I want to give her credit where credit is due. She got almost all the way through this on her own without a lawyer and did a great job. I'm here today pro bono on this. I'm not charging her a penny because of how important this issue is. On the question of standing, we had cited to the administrative law judge an Iowa Supreme Court decision that takes a much broader view of standing than what has been argued here. It's a case from 1955. With all due respect to the board's prior decisions and to what its administrative law judges have recommended in the past, as this board, I think, probably knows or should know, that the legislature has not granted this board the ability to interpret these statutes for itself. Iowa Supreme Court has said that any parent with a connection with the school district is aggrieved for purposes of challenging a decision of a local school board, and that's what Ms. Patrick is. On the merits of this, I was struck at the hearing that was conducted before Administrative Law Judge Mays in asking the superintendent of the West Des Moines schools, give me an example of a book that would not be appropriate to have in the library for middle schoolers. Give me any kind of objective criteria of something where you would say there's no educational value to this material. It is not appropriate for the school environment. And she could not come up with a single thing. Not one thing. Not one objective standard as to why this would be inappropriate to have in a middle school environment or any school environment. Now, what my professional colleague, Mr. Mays, has told you is that it's a deferential standard of review. That's fine. But a deferential standard of review presumes that at some point, somebody has actually made some decisions based on something more than just shrugging their shoulders and going along with whatever is happening. And that's exactly what this process is. There's a building committee to approve materials, and they all say, well, I guess it's okay with us. And then another level of review and no objective criteria. And then it goes up to the school board. And there's no objective criteria at any level. And then you're asked just to defer to what? Now, Mr. Mays did not include in the administrative record the actual book because of purported copyright issues. I've got a copy for everybody, but we're talking graphic depictions of sex acts. And I want to be clear, it's not because it's two boys in here. Okay, that's not the point. That's not the point of this. I don't care if it's males and females, I don't care if it's adults, whatever it is. It's not same sex, opposite sex, or anything like that is the issue. The issue is we all understand the context that this is happening in. Parents feel that the public schools are absolutely out of control and disregarding their interests and what they want to see.
Mr. Ostergren, wouldn't the parents have a recourse at the ballot box if that's so far outside of their standards?
They do over time, and reform is coming. And reform is coming. And really that gets into a point here that we all know reform is coming one way or another to public education. It has come and it is continuing to come. And the question is, will the infrastructure of public education in Iowa show any ability to reform itself? Is there going to be any ability to do that? Any sliver of anybody in authority standing up and saying, you know what, maybe we're going a little too far. Maybe we're sexualizing children too much. Maybe we should listen to people and not just assume that because we're credentialed, we know everything. That ultimately is what this is about. And if reform doesn't come from within the public school infrastructure, it's going to come from without it. And you're probably not going to like what that reform looks like, but you've lost almost every chance you have to show that you can fix yourself. Nobody has taken responsibility in the West Des Moines schools for an actual objective reason why this kind of stuff needs to be in a school library. Nobody. And then they're going to come here today, and my colleague is a very fine lawyer from a very fine law firm. And she will cite to you deference, and they follow the rules, they follow their procedures. The whole thing's broken. You are appointed by law to superintend how school boards function, how the system of education functions in our state. And you would make an enormous impact by simply saying, you know what, This is too much. It's too far. Those are my comments. I'd be happy to answer any question that you have. Yes, sir.
Just to follow up on my first question, if change is coming, if that's inevitable, why does the board need to act at all? Why would that be less legitimate than action here?
You don't, it's up to you. Deep down, if you don't act, it makes the example for why reform is all the more important from an external source. If you do act, it shows a capacity for the public school infrastructure to fix itself. You don't have to. I can't make you do anything. You don't have to do anything.
I suppose my question is, assuming you're wrong about the external changes, let's say the voters in West Des Moines have an opportunity to elect new school board members and they don't do anything about this, and we, in a bureaucratic appeals process, change it for them. How do you know that this was the right change versus what the will of the voters, against the will of the voters that have elected the school board members that are currently in office and presumably, if this hypothetical plays out, would still be in office after an election? Wouldn't that make our decision to supersede their will illegitimate in some sense?
No, because you're here right now with the authority to review the decision that was made there. Yes, in time, what has been happening and is continuing to happen is parents are waking up to how broken aspects of public education are and are trying to fix it. Yes. Okay. But if the answer is, they're elected, therefore, who are we to question their decisions, then we should end the meeting and you should resign from this board, because what's the purpose of this board then, if not to supervise those decisions?
Do we know of any schools in Iowa that's actually established standards for library books? Do we know of anybody who's sit down and these are the criteria this book must meet?
I don't know that, and I would like to know the answer to that question. I certainly got into this pretty late in the process, so I can't answer that.
I'm a layman. I don't understand standing completely. I don't always get it. So this student, would this student have access to that library even though this student isn't in that building? So, could I'm an 8th grade student, could I go to the 9th grade building and say, gosh, you got a great library here, I'd like to check out a couple of your books? Could I do that?
I don't know the specific answer to that question. I'm going to assume no. Okay. It's a 1-year building. There's a process in place. This is West Des Moines decided to have a single grade building, which is fine. I'm sure they have a good reason for that. What standing means is your ability to go into a proceeding to contest some application.
Yeah, I understand that.
Yeah.
It affects me. It directly affects me in some way. So my brother could check the book out and give it to me. My sister could check the book out and give it to me. My friend next door could do that. I could still get the book.
I think, right. Once it's checked out, it can go to anybody, obviously.
Okay.
So I have a question. Can you tell me why we should even be talking about the merits of this when 290.1 talks about you have to be the parent or guardian of an affected student in that school? Why should we get to the merits of it? If your client had her child in the school, obviously we'd be okay. But why should we do that in this case?
Because the Iowa Supreme Court has said that someone with a connection to the school district like she has, it qualifies as an aggrieved person.
Notwithstanding the statute.
What I'm telling you is that's what the interpretation of the statute is in the court case that we cited, the administrative law judge.
And 1955.
Well, that's how court decisions work. They're in place until they're overturned.
The statute is much newer than the court case.
How the court defined the word, interpreted the word aggrieved, was somebody with a connection to the school district could pursue the appeal to the state board.
Does the decision of the school district and school board in West Des Moines affect or bind other schools in the district? Or is this just limited solely to Southwood?
So the most direct application of, if you were to reverse the decision, then that directly would only apply to the West Des Moines schools. That would become an administrative precedent. And then work would go on with other school districts, and perhaps other school administrators would rethink decisions that they had made in light of a board decision along those lines.
What I mean is if, for example, I don't know the circumstances of the student involved here. It's a one-year program, presumably they went on to the 10th grade. My guess would be at Valley High School. Is that book available at Valley High School? And does the decision of the West Des Moines School Board in determining the appropriateness of this book in the library at Southwoods, is that also, because if the student was agreed to Southwoods and the book is in the library at Valley, the student would still be agreed, correct?
So there's the direct legal effect, which is much more narrow, then there's the practical effect. And I'm confident that if this board were to overturn the West Des Moines School Board's decision here, then my colleague would have, my friend on the other side of this case would have to have a conversation with her client about the use of that material elsewhere, as they would in every school district.
Okay, thank you.
Is the book in any other building in the district?
I don't know. On our administrative record, it's at this middle school building.
Recognizing part of the decision noted that reasonable minds could differ on whether the challenged book should remain on the shelves. Was there any other public comment for or against the book being retained?
There was I think a very full and vigorous debate at the school board level with concerned parents. Ms. Patrick is the one who took on the responsibility to get this to where we are procedurally, again, without a lawyer helping her, which I appreciate. But yeah, and as was noted, this was not a unanimous decision of the school board. This was a debated point there, and the community was engaged with it. Obviously, the vote went the other way, which is why we're here.
How would you gauge the public perception in that debate? So I understand the school board's decision, but how would you reflect the public debate to the school board?
I think it reflects the debate that's going on all over Iowa, that parents are beside themselves at this feeling of loss of control of what's going on in public schools.
But was the debate to the school board for or against keeping the book in the library?
I can't give you an exact breakdown of the comments. I know there was significant opposition. I can't represent whether or not there was comment in favor. I don't know that. I have no idea if I'm over my 7.5 minutes. I'm sorry.
You are.
Okay.
Are there any other questions? Hearing none, we'll go to the other. Thank you.
Thank you very much. Thank you.
Hello. My name is Christy Latta. I'm from the Allers Law Firm, and I'm here on behalf of West Des Moines School District. I guess I'd like to start with a few comments from Mr. Ostergren. The building at issue is not, I guess, what I would characterize as a middle school building. It's a 9th grade building. So it's, for most purposes, considered high school level. So it's a 9th grade building, freshmen. 14, 15-year-olds, I think, probably be the general age range that are there. I do disagree with the characterization of the superintendent's testimony at the hearing. I think if you looked at the testimony in its totality, it was clear that we weren't there to talk about any other book except for this one. And so I personally don't think, that idea of wanting to sort of speculate about something outside of what could be appropriate, what couldn't be, really not, necessarily the forum for that particular conversation. And then, with regard to, I guess, how we got to where we are, this is the appellant's 6th bite at the apple. Okay. So we started with the complaint that the appellant made internally pursuant to the district's complaint procedures. That was reviewed by a building level committee. Lots of school districts in Iowa have these sorts of policies for how to reconsider library materials. So the fact that Mr. Ostergren says there's no objective criteria is just not the case. In the record before the administrative law judge, policies were submitted that talk about materials, controversial materials, objectionable materials, what factors are to be weighed in those situations. And then there's even this policy and protocol for what to do when you get a complaint. So the complaint came in, it was reviewed at the building level. There was most definitely not any sort of cursory review. I mean, the administrative record is clear that there was a lot of conversation at that building level committee about what to do. The committee ultimately decided to keep the book on the shelves of the library. Again, just to be clear, not required reading, not part of the curriculum. It's just sitting on the shelf in a library. So optional, voluntary, all of that stuff. And as the superintendent testified at the hearing, to the extent that any parent didn't want their child the ability to check that book out, they could make a note of that and that would be accommodated. So that's, I think, another important distinction here. But, with regard to that policy, after the building level committee decided to keep the book, the appellant took it to the next level, which is an administrative committee. It's like a teaching and learning advisory committee is what they would call it. So the building level committee's decision was reviewed then at the administrative level. The administrative level also put together a decision affirming the building committee's decision. That decision then goes to the superintendent. The superintendent affirms that administrative level decision. So that's about, the third iteration of review. At that point, then, that decision was further appealed and it went to the school board. So then we had a school board special meeting to talk about this particular issue and whether or not the administration's recommendations should be affirmed. So that's the fourth level. And the appellant appeared there before the board. There was vigorous discussion, public comment on all sides, lots of back and forth and dialogue between, the board members and the appellant. So there was most certainly, a consideration of all of the factors and all of the dynamics that were at play. After that, the board ruled, as was said, not unanimously, to keep the book in the library. Then the appellant appealed further. So that was the fifth time at the state board level with the administrative judge. So the administrative law judge heard all of this, reviewed the record, and agreed to affirm the decision of the school district. And now here we are again at this particular point in time. And my two comments that I guess I want to make sure I communicate to you is that first and foremost, I don't know that we get to the merits here. I think there's a jurisdictional issue with regard to the fact that this is not a parent of an aggrieved child. The child doesn't attend the school where the book is at. For that reason, they really cannot be aggrieved. And I guess what I would point out is that case from the 50s that was cited by Mr. Ostergren predates the idea of 290.1's affected and aggrieved. So it isn't just that you're aggrieved, you also have to be someone who's affected. That's what the statute says in order to, retain jurisdiction. So I don't know that we even get to the merits because I don't think that there is jurisdiction for the state board to hear something of this nature. With regard to, could someone's sibling check it out, or could you in some way, shape, or form have access to the book? Sure, but I guess I'd say no more than going to the public library or no more than pulling up the internet, right? So that idea of having standing requires something more direct. So again, I don't really know that we get to the point where we're at the merits on this particular case.
Ms. Latta, if I could just ask you a question about that. When did this student cease being an agreed party by your lights?
How old is your child now? It was prior to the institution of this appeal. Sophomore.
So if I read the record correctly, you appeared before the administrative law judge on June 8th. And so presumably this student had graduated and left Southwoods by that point and was not an agreed party by understanding of that.
Correct.
Did you brief that issue?
Yes. The administrative law judge requested supplemental briefing on that issue.
Or before the fact?
After the hearing.
As you went to the hearing on June 8th, you felt that you didn't have a standing issue at that point.
I was thinking that there was a possibility of that, but since we had already seen the whole process through at the board level, we went forward with the hearing. And I guess what I would say is that at any time there's an issue with jurisdiction, the state board is obligated to raise that. You aren't really able to waive the question of jurisdiction when it comes to an aggrieved party.
In this particular case, do you recall when the first bite at the apple took place, I guess, to use your language? What date was the complaint first made?
I have someone here from the district. I'm trying to remember. It's in the record. I don't know specifically when.
To frame my question more broadly, we've got a school, so it's only there for 9 months. And this appeals process now has taken in excess of 10 to
Right.
get where we are now. So if that's the case, any student or parent who is aggrieved at Southwoods would lack jurisdiction necessarily. That's our understanding of standing, correct?
Right.
They'd only be able to appeal to a certain point before all of the other forms of appeal to which they would legally be entitled otherwise are out the window, simply because of this kind of curious nature of this school.
Right. Well, I think to the extent that the student is an aggrieved party, perhaps at the time,
Right.
the time that the claim were to accrue,
Yeah.
then I think that, you would be able to retain some sort of sense of control at that point and authority.
But then they lose all of their legal recourses simply by dint of the 1-year nature of this school.
Yes, I suppose so.
Never be resolved if it continue. Like no student, no aggrieved party who brings up this very same issue at this very same school ever will be able to come here and find recourse.
No, I don't believe that's correct, because I think what you'd be able to do is file the complaint as an aggrieved party under 290.1. So, whether or not there's the internal process with regard to the school district, right? That's a separate question. Those are internal procedures with regard to the board and their policies. Whether or not then there's that board decision that would allow for the aggrieved party to be so aggrieved under 290.1 at the time, I think is a separate issue.
So if I'm following this a little bit, just if I file this complaint when my student is in 8th grade, and I can't say that my son or daughter is going to be affected by this decision because they're going to that building next year. So I want relief. Is that out of line? I mean, I'm saying that would I have to say my son's going to that building next year. That book is on there. It's like my son's standing on the interstate. Here comes this truck and it's going to run over him unless I move him. So is the obligation on my part to move my son to a different building? Is this the only building? The only 9th grade building?
I think at the time of this issue, it was the only building with the book. I think there may be other buildings with
Okay.
it, potentially at the high school level. I just don't know for sure.
Yeah, I'm following that conversation. I mean, when would you ever have
Well,
seen
to your question, that's not the precedent of the state board. The state board has said, it's not just that, hey, you might be a kindergartner and we put together a policy for varsity football and you don't like it and you get to see the truck coming, so to speak. You have to actually be affected or aggrieved.
Yeah, I hear. You said that there are written policies about the books when we select those books. Did you bring that, or is there?
Yes, that is in the administrative
Is it
record.
okay, in the record?
Yeah.
Was the child ever a student in that building?
Yes.
So when she started the complaint process, was the child in that building?
No, he was a sophomore at that time.
He was a sophomore. Okay. So he had already left the building.
Yep.
Was the book on the shelves while he was a student at that building?
I don't know. I'd have to go back to the school and look. I feel like it probably was, but I don't know.
Yeah, and I don't know the answer to that, but I think what is clear is that this was a 10th grader not attending Valley freshman 9th grade school when the complaint was brought. So just to make that totally clear, it's not a 10th grader now, right? The child is not a 10th grader now.
Your understanding is that if presumably a hypothetical 9th grader day 1 files a complaint, even if they graduate and leave that school and go on to another grade,
Yes.
that they would maintain standing.
Yes.
And so-
Yes. I don't think you lose it because, it took too long, right? Yes, I think that's okay. Now I understand, I think what you were asking. No, I don't think the board loses jurisdiction because all of a sudden, no, it's been timed out. No, I think the reason the board never even had jurisdiction was because the student wasn't even in the school when the complaint was filed about the book in that school.
I understand. Thank you.
Yes.
May I ask a question of the district representative?
Yes. Yes.
Could a student go to that building from another building and check out the book?
Not that I'm aware of.
We do have students that can go between buildings because they're concerned, maybe one class or another class between our buildings, they could go there. But I don't think that they can just walk in. Positive about that, but I don't think so.
Thank you.
Okay, so again, I stand by the jurisdictional piece here, but moving to the merits, if you were to want to go to that portion. In this case, the board ultimately is who you're reviewing. So we had these 5-6 bites at the apple, but ultimately, if it's the board's decision that you're looking at, the board here made a determination, not just based on the pictures that were shown to you, but based on the book as a whole. So the board decided, and all the committees before it decided as a whole, in its entirety, they decided it had value, okay? I think that if it had gone the other way, if the board had decided not to have the book, and certainly I'm sure there are districts that might make that decision, I would venture to say I may be sitting here anyway, right? There would be someone on the other side who would be upset that it's not available. And so I think that to me is very striking in the sense that this is one of those situations where, reasonable minds can differ. And you might not like that book or might disagree with it, but the people that were charged with making that decision, and not just the board members, right? But, all the committee members and all the administrators all the way on up, spent lots of time on that, looked at the book as a whole, right? And made that determination for this particular district in this particular case. And so I think what the argument that I'm trying to make here is not so much, in support of the book itself, just as if I was sitting here with a different appellant on the other side, I wouldn't be, saying that the problem is with the book itself. I would say that the issue here is one of a decision that is vested with local school boards, right? These are the people that are elected by the community in which they live. They are elected to serve those people, and they're responsible to their constituents. They listen to those people and they get that feedback. And so when they make those decisions, I think, yes, if there's dissatisfaction, if someone's not happy, the remedy is at the ballot box. I think if there's dissatisfaction or someone's unhappy to a certain degree, they can make another choice then about, whether or not that's a school that they want to attend. They can take steps to say, I don't want my child to check that particular book out of the library. So what I believe the appellant is asking for, if you were to reverse the decision based on the merits, it would be a sea change for the way that this prior state board has acted with regard to its precedent. It has always been, for the 16 years I've been practicing law, it has been, the idea is, look, there's a zone of reasonableness. It's like a football goalpost. And, you might be a little on the left or a little on the right, maybe down the middle sometimes. But as long as you make that football go through the goalpost, if you're within that zone of reasonableness, then this board will defer to the decision of the local board. Right? It's only in those cases of an extreme abuse of discretion. And that's just not here. It's just because you strongly agree or might be, the loudest one in the room doesn't make the decision one that isn't supported by some sort of reasonableness or rationale. So I guess that's what I would really ask, is that you consider the idea that the precedent longstanding has been not to substitute your decision for that of the local board, but rather to, look at what the local board did and simply affirm it based on the idea that they did their due diligence. They looked into it. They followed their policies and their protocols. And regardless of the outcome, it's within that zone. It's within that zone of reasonableness. The idea of essentially being able to second guess and substitute one's judgment would have extreme consequences, I think, for every local board and every decision they make, not just with regard to what's on the shelf in the library. Thank you so much. Are there any questions?
Thank you.
Yes, thank you.
Thank you.
I was on a plane in South America last week, so that's why I'm still wearing this. I don't want to bring any souvenirs back. and share them. You've heard arguments of counsel. Just for clarification, the entire administrative record was made available to the board, exhibits, briefs, motions, the complainants, the affidavit of appeal itself, including all the attached exhibits, as well as my notes from the trial setting, the scheduling call, as well as the hearing itself. With that, my proposed decision is just that, proposed. You are final agency action. If you have any final questions for me or either of my colleagues, I'm at your disposal.
So I have some procedure questions for you. And take this issue aside. For me, it's just better understanding our role because there was an appeal, I don't know, 3 or 4 board meetings ago that I probably had some issue with. And so I just want to understand. So for us as a board, is our only role just process? So if an appeal comes to us, our role is just to review it to make sure that it followed the process, or is our role to actually look at the merits and give an opinion or not?
It's both and, but the question about the merits goes to the rather robust argument about scope of review. Like how closely do I look at the merits? How much how much does this board substitute its judgment? When is it permissible to? This board has reversed on the merits before. It has reversed on the merits before regarding bullying and harassment, which is no longer part of its jurisdiction for open enrollment cases. The appeal that was on your consent agenda earlier today, it has reversed or modified local board decisions on discipline. In one notable case involving the district before you today, where this board found the local board's decision was objectively unreasonable.
Right.
That the discipline imposed was objectively too harsh, but that this board made a finding that no reasonable mind would have imposed that discipline. Mm-hmm. So it's not just a process review. Process is important, but it's also looking at the merits, but the looking at the merits is if reasonable minds could differ then.
Okay, so this issue aside, if we had concern about an appeal, then we could take a side that isn't just, oh, you followed the process, so we're just going to go along with what you had to say. I mean, we could take a side to where we can overturn it. And you're saying that has happened before.
I mean, you are final agency action. It has happened before. The parties have judicial review rights. Your final agency action would be subject, regardless of what your final agency action is. Your final agency action is subjected, could be appealed to district court in Polk County.
Okay, that's what's going to be my other question. So let's say today, again, I don't want to talk about it based on its issue, but just in general, if we just said, yeah, we agree, then the people who brought this case forward in the appeal, what's their next path? Or just
as mentioned in the
just going to court.
As mentioned, the next step available in the Iowa Administrative Procedure Act is a petition for judicial review in district court, either Polk County or where the parties reside.
Along those lines, if we disagree with a portion of the opinion as you wrote it, or take issue with it in some part, is it possible to amend it? Or if we disagree with the finding entirely and overrule the board's decision, what's the process for issuing a new opinion, and what does that look like?
Historically, when this board has modified or reversed a proposed decision, the administrative law judge receives directions from the board and brings a new decision back to you.
And as a matter of appeal, if this is going up, before a district court judge, what part of the record did they have? One of the things I was dismayed about is that I didn't actually have, there was some information about substantively about what the board members discussed below and what their thought processes were, because it's very hard by my lights to determine whether someone's being reasonable or unreasonable if I just have their yes or no. How they came to that conclusion is significant to me. So how much of our decision here will be available for appeal? Is this all memorialized and will be part of the record for them, or?
Your minutes, your record of proceeding would be available to district court.
Mr. President, I'm not swayed by the argument that the parent has standing. I don't believe she does. I also believe that 290.1 controls the rules of outstanding, and that we're bound by the most recent legislative rules in that regard. My suggestion is that we affirm, but that we strike everything that starts with merits from pages 3 through the end, so we get to the order. We simply don't have jurisdiction. This may be a very interesting question. It's very political. It's very timely, but this case isn't before us, in my view, because we don't have jurisdiction to hear it.
And you're saying that because you don't think they had standing?
Correct.
Okay, I just want to make sure I'm following you.
Correct. I don't want to pass on the merits one way or the other. I don't think we can.
I just a couple of comments. I'm really sorry that we have to get into this discussion.
We have a point of order, if we would. You made a motion.
That's a form of a motion.
Okay,
Yes.
is there a second to that motion? Hearing none?
My apologies.
No, you're fine.
Good. I frequently get ahead of myself. First of all, Counselor, you did a heck of a job of getting good information out to us. I appreciate what you sent us. Seems to me like it was spot on, all the things that helped me as I tried to work through this. And so, Counselor, I can't believe you've been practicing law for 16 years. You're much too young.
Oh, well, thank you. Let the record reflect.
I think we're right. I think reasonable people can make reasonably different conclusions or draw different conclusions concerning this. My personal opinion, the book shouldn't be on the shelf. And not so much because of material. I just, at that particular age, I think kids are pretty vulnerable. And I just don't think it has any place on that. And I think in education, we get into these arguments, as the counselor presented. We start arguing about the wrong things. We're discussing the wrong things. And we're spending time on the wrong things, to me. Just have to make better decisions than that. But I understand they're reasonable people. And they made a reasonable decision that they thought was best for their district. And I really appreciate that. I'm going to pose this. But again, it's just my feeling that we have to begin to look at these issues and say, in what ways does this help our kids, or is it more divisive than we really want it to be? And it's going to split our community. There's a lot of other things we should be arguing about or discussing, I should say, than this issue. Thank you.
Is there another motion from the?
I'd just like to add that I think everything that's about the merits here is us giving advice to people, or an advisory decision about a matter that's not properly before us. I hope somehow we come to a conclusion that we don't have jurisdiction, because I think it's the dangerous precedent to start saying what you think about things not properly before you, and the law of unintended consequences. There are other ways that this can be addressed besides us ruling on the merits of something that's not properly before this board.
What's the advice? You said that we should be giving advice. What's that advice?
The advice is all the comments about the merits. Commenting on the underlying dispute about whether the book should be on the shelf or not.
You're saying it shouldn't be there because we shouldn't even be looking at it.
No, I'm not saying that at all. I'm saying I'm saying there's no jurisdiction, so we don't make any comment for or against any of this.
I just want to make sure I'm clear. And you're saying there's no jurisdiction in your mind because go to that school.
The appellant has no standing.
Got it. Yep. I just want to make sure I'm tracking you.
I try. I mean, I take this seriously, and I think we should try to do it as legally as we can, and I don't think we should overstep our authority. I think we are if we rule on the merits.
But there is a question of jurisdiction. And that could be,
There could be. That's why I made a motion and nobody seconded it.
So, I mean,
You can all agree that they do have standing. I'm saying under 290.1, they do not.
we may.
Like we don't on open enrollment anymore. The statute changed.
As a board, we may decide that we have standing and then we decide on the merits here. And if we're wrong about the standing issue, somebody in a black robe is going to tell us that. And our merits decision won't have any effect.
They are.
And we may be tilting our hand or dissuading further litigation on the issue by issuing an order, by forming an opinion about something that ultimately is not effective because there's no standing. But I don't think, we owe somebody a decision here today. There's parents involved, there's children involved, and I think that that's our responsibility. So
I just don't think we just pass it along for the parties to go to court. We should decide whether we have standing or not. If the board believes we do, then I can vote no.
then in that case, I move to find that the board does have, the claimant appellant does have standing and the board should rule on the merits.
Thomas, should the board decide to...
Point of order, please.
I'm sorry.
There's been a motion that the board does have jurisdiction. And can you restate the last part?
And that the board should move to decide on the merits.
Okay. Second. It's been moved and second. Now we have discussion. Rod?
Thank you. Thomas, should the board decide to overturn the local board's decision, what impact does that have on the building? Would that require the book then be removed from the library, or would they go through an appeal process to the district court themselves? Or could they? I'm sorry, not would they?
Administrivia here. Your board's decision would become final agency action. Whoever's aggrieved and appeals to district court could ask for your decision to be stayed. And there are specific procedures under the Administrative Procedure Act in district court to allow your decision to be put on pause while judicial proceedings move forward. So the question of what happens after your decision is largely between the parties and whether or not they choose to go to state district court, and whether or not the state district court, under rules about entering a stay or putting your decision on pause, whether or not they grant, whether or not they put your decision in timeout.
Thank you, Thomas.
Further discussion?
Could I have the motion repeated back? Because I didn't understand the second part, but maybe I just misheard.
I move to for the board to find that we do have jurisdiction and so that we could proceed to the merits.
Point of order, Mr. Chairman.
Yes.
Can we do that without splitting it? Kind of said that. You said that, and we want to split this and take this issue of jurisdiction first. But do we have to split that formally? Do we have to vote on that? And then?
We're going to have to vote on his motion because it's been second.
Okay.
I do have a comment. I would contend that we do not have jurisdiction. I would also contend that the board is treading on thin ice to say we have jurisdiction. And I would also contend, I'm not arguing the merits of the case as far as whether that book should be on the shelves or not on the shelves. I'm just thinking if the board decides we have jurisdiction in this case, it will become a book review for the state of Iowa. If that's where we want to be. That's my opinion.
And can I ask your opinion on why you don't think we have jurisdiction?
We don't have jurisdiction because the student is no longer a student at Southwood. We don't have jurisdiction because the appeal was, or the original contention was when he was not a student at Southwood. It was after the fact. If we would start when he was a student at Southwood, I would feel differently about it.
Call a question.
It's been, it's been moved that that the state board does have jurisdiction and that it should examine the merits of the case. I'm paraphrasing. Is that close enough, Karen?
Yes, thank you.
Okay. We'll have a roll call vote. Yep.
Bradley?
First, let me say I have a grandson going into middle school this year. He'll be a ninth grader. The materials that I reviewed are offensive. I find it hard to believe that so many reasonable adults found it to have any true literary value for my grandson or anybody of his age. I think one of the points made by the aggrieved party was that Amazon lists the book as an adult book over the age of 18. I looked it up on Amazon. That is how it's rated. So I think it would be akin to a teacher showing a movie that was never intended for ninth graders in a classroom without the parents' knowledge. So I'm going to vote yes.
Pauls?
No.
Yeah.
Nay.
Could you just be just a little bit louder?
Oh, sorry. May?
Yes.
Peterson?
This is just for the issue of jurisdiction, correct?
No, it's your whole motion.
Okay, so I vote not to affirm the decision.
It's clear. It's clear.
My motion is on jurisdiction. And so
We're voting, do we have jurisdiction?
okay, proceeding to the merits. Yes.
Robbins?
No.
Van Gundy?
No.
Yeah.
Motion fails.
I would like to move again that we find that there is no jurisdiction for the reasons John just stated. Student was not a student when the appeal commenced. And that there's no jurisdiction under chapter 290.1. And we should not get to the merits, just to be clear.
Motion's been made.
Second.
There's a second. Any further discussion?
I'll just share one thought. I think the point of the reasonable minds could differ, and the fact that the school board did entertain public comment on this issue and that opinions were shared in that public forum is really important. I also think that having parental control in the library and that parents have an ability and a mechanism on a local level to express their concern and have control over what access their children have to materials in the library is really important. So having local control over those issues, and as a parent having local control over those issues, is still a protocol that the jurisdiction retains. So there's parental awareness issues on both sides of this issue that I think as a parent having a child in any district that a parent has to have ownership of. So that's just the thought that I share when it comes to merits.
Okay, so we have a roll call vote on the motion that the plaintiffs do not have the jurisdiction.
One question. Who second?
I did. Thank you.
So roll call vote, please.
Yes. Bradley?
Affirmed.
Pauls?
Affirmed.
Kane?
Aye.
May?
No.
Peterson?
Nay.
Robbins?
Yes.
Van Gundy?
Aye.
Motion carries.
Okay. We will move on.
So President Robbins, I will have a revised decision for you, noting that the board's vote was limited to the question of jurisdiction.
Yes. Let's take a 10-minute